They mentioned item 13.
Item number?
13.
Yes.
On behalf of Madhumati Kothari.
Okay.
Can they arrange for 4th of September?
4th of September. Have you enrolled the other side?
Yes.
Okay. On the prayer made on behalf of Dr. Madhumita Kothari, the council for the appellant listed on 4th of September.
4th of September.
May I please lordship? May I make mention item 12?
Yes.
Here, my lord, I have been appointed as amicus curiae. This I have not properly prepared today.
Okay.
Therefore, my lord, this may be listed after 2 weeks.
Okay. On the prayer of M. Bosne, learned amicus curiae, listed after 2 weeks.
Evidence.
Deeply obliged.
Item number 1. This is the same matter
My lord.
where Supreme Court is.
Yes, my lord.
We had taken one order yesterday. Same order.
Yes. Deeply obliged.
May it please your lordship. Lordship, I have claim juvenility in this appeal, Your Honor, my lord. I have not challenging the conviction. Just I'm claiming juvenility. At the time of commission, I was 17 years, 4 months and 19 days. And date of incident was on 23 August 2014. And my date of birth is 4 April 1997. And I was 17 years, 4 months and 19 days at the time of commission. And my lord, the fact lead to filing this application is that I have in paragraph 4, 1st November 2022 to 3rd November 2022, Legal Services Authority, Papum Pare, Arunachal Pradesh, has conducted an awareness program, Hak Hamara Bhi To Hai, as per the direction of National Legal Services Authority, New Delhi, nationwide Pan India Legal Awareness and Outreach Program under Azadi Ka Amrit Mahotsav for the petitioner at the district jail Jubilee. The prescribed questionnaires to interact with the prisoners in Annexure B was put to every inmate. When question number 12.
No, what is that? How is that relevant for determining your juvenile?
My lord, Your Honor, during trial, Your Honor, I have never raised juvenility.
Okay.
So at the time, Your Honor, I was not properly supported from my family.
What you have been convicted under?
Under 302, life imprisonment. I have been convicted for life imprisonment.
Oh, no.
So my lord, at that time, Your Honor, in the year 2022 November, Your Honor, I came to know that I was juvenile, Your Honor. So I have approached my mother, and my mother has sent me the matriculation certificate of issued on 24 May 2012. 24 May 2012. It is CBSE certificate issued, Your Honor, in which, Your Honor, my date of birth is shown as 4 April 1997. And I have original of the CBSE certificate.
If you rely on CBSE certificate, class 10 certificate,
Class 10 certificate.
you are a juvenile.
Yes, Your Honor, my lord. This is the original.
Yes, your lordship, so far as the juvenility is concerned, your lordship, the other party, since for presumption, your lordship, there are certain material has been listed out in the section 94 of the your lordship Juvenile Justice Board Act. So if there is a matriculation certificate, your lordship, the presumption can be drawn, no doubt, your lordship, but it has to be determined by the board or the learned court below. Why I'm saying learned court below? Because evidence has to be adduced by either both the parties, and they have to prove the document according to 35 of the Evidence Act, Your Lordship, because it's a document issued by the of some certain authority. So, Your Lordship, then in that case, if they are claiming the juvenility, if Your Lordship is satisfied and Your Lordship draw presumption, then Your Lordship, keeping this appeal pending, Your Lordship may direct to constitute the direct the board to determine the juvenile, determine the age of the Your Lordship, the accused.
My lord, when the offense was committed, Juvenile Justice Care and Protection Act 2000 were enforced, and the provision of Juvenile Justice Act 2000 would be applied for all purposes, my lord. In section
Yes,
7 of
which is-
7A,
Which is the provision for determination of juvenility?
Your Lordship,
yes,
the
2000,
94.
Your Lordship, section whichever they are relying, that was the or the earlier act. And so far as Your Lordship, present act is concerned, and repeal and saving clause, it has been clearly reflected that the any act or any application which has been entertained will be considered as it's considered as if it is considered on the section available on the earlier act, because none of the sections has been omitted, Your Lordship. It was only renumbered, and a rule has been, Your Lordship, conjunctively, Your Lordship, enacted inserted in section 94, Your Lordship. 94 of Your Lordship JJB Act, Your Lordship.
my lord,
So determination has to be made under 94.
Yes, Your Lordship. That is the procedure, Your Lordship.
that is 2015, Your Honor, 2015 JJ Act, Your Honor. In 2008, my lord, in 7A, section 7A, subsection 2.
See, just a minute, slowly. Juvenility is determined in accordance with 94. Correct.
Yes, in 2015 Act.
Now that has been amended.
Yes.
The present
No,
act.
that is
That is
amended
the
in
present act, Your
2021, it was amended.
That is the present act. As for the present act, section 94, Your Lordship.
Present Act is 2021 Amendment Act. An incident was happened in 2014,
Which there are two acts, 2015 Act,
2000.
2015 Act.
Your Honor, 2000 Act, Your Honor.
Okay, 2000 Act,
Yes,
And
2000 Act,
2015.
2015.
15 Act.
Yes, in this case, Your Honor, my lord, incident will happen in 2014. So 2000 amendment, 2000 Act applied in this case.
2000 Act will apply.
Yes,
Okay. Under 2000 Act, juvenility is determined under
section 7A,
7A,
Yes.
Your Lordship.
section 7A.
And okay, you did not raise the, you did not take
No.
the plea of juvenility before the,
During trial, I am
Trial.
not claiming.
now you are
Not
before
raised.
this court in the
Yes.
appeal.
I came to know I was juvenile only in November 2022
No.
during awareness program.
Now who will determine the juvenility?
As per Your Honor, 7A also, Your Honor, in subsection 2, Your Honor, my lord. May I read your, my lord?
No, okay.
It is, if the courts find a person to be juvenile on the date of commission of offense under subsection 1, it shall forward the juvenile to the board for passing appropriate order and sentence, if any, passed by the court shall deem to have no effect. And rule 12, my lord,
See, just a moment. Section 7
7A.
is provides for
7A is Your Honor,
Procedure-
procedure to be followed when claim of juvenility rise before any court,
procedure to be followed by whom?
followed by Your Honor, any court, rise, juvenility is raised before any court.
Okay. So if you fail to raise the plea before the trial court, and you raise it before the appellate court, now who will determine the juvenility? It is the appellate court who will determine, or the,
Your Honor, as per the rule 12, every any court or board or in case maybe the committee, it is child welfare committee, can decide the juvenility. May I read the section rule 12?
you please read and also tell us who will determine the juvenility.
Procedure to be rule 12, procedure to be followed in determination of age. In every case concerning a child or juvenile in conflict with law, court or board, or as case may be, the committee referred in Rule 19 of these rules shall determine the age of such a juvenile or a child or in a juvenile in conflict with law within a period of 30 days from the date of making of the application for that purpose. Sub-rule 2, the court or the board, or as case may be, committee shall decide the juvenility or otherwise the juvenile or a child, or as the case may be, the juvenile in conflict with law, prima facie on the basis of physical appearance or documents, if available, send him to observation home or in jail. Sub-rule 3.
Yes, Jaya, tell us what is to be done.
Uh,
Don't read. You have read at home also. Now you have also read.
Yes,
Just
yes.
tell us what
Uh,
is to be done.
in
under the-
Your Honor, my lord, in sub-rule 2, my lord, I have,
You are still on sub-rule 2.
yes, sub-rule,
What is your understanding of the reading of the provisions?
reading of the provision is, my lord, court or board can decide the juvenility as per Rule 12.
Court or
Court or board or the committee.
board? The court referred to that.
Court refer to any court.
Any court.
Yes,
We can also determine.
yes, my lord. As per the Rule 2, it is. And even after the conviction of the offense, my lord, even after disposal of the case.
Your Lordship, I place the judgment of the Recipal Solanki case, Your Lordship, regarding the determination of age of juvenility, wherein both the act has also been, Your Lordship, reiterated by the Supreme Court. Lordship, I have just given the citation, Your Lordship. If Your Lordship allow, then I can read out, Your Lordship, the provision, the parameters, Your Lordship. Both the act has been discussed in this case, Your Lordship, by the Honorable Supreme Court, Your Lordship, which was reported in 2022, Your Lordship. May I read, Your Lordship? A claim of juvenility may be raised at any stage of a criminal proceeding, even after a final disposal of the case. A delay in raising claim of juvenility cannot be a ground for rejection of such claim. It can also be raised for the first time before this court, even the Supreme Court, Your Lordship. An application claiming juvenility could be made either before the court or the JJB board. When the issue of juvenility arise before a court, it would be under subsection 2 and section 3 of the 9 of JJB Act 2015. But when a person is brought before the committee or JJB board, section 94 of JJB Act 2015 applies. If an application is filed before the court claiming juvenility, the provision of subsection 2 of section 94 of the JJ Act 2015 would have to be applied or read along with subsection 2 of 9 so as to seek evidence for the purpose of recording a finding stating the age of the person as nearly as may be, Your Lordship. Evidence, it says, evidence, Your Lordship. When an application claim juvenility is made under section 94 of JJ Act 2015 before the JJ board, when the matter regarding the alleged offense is pending before a court, then the procedure contemplated under section 94 of JJ Act 2015 would apply. Under the said provision, if the JJ board has reasonable ground for doubting regarding whether the person brought before it is a child or not, the board shall undertake the process of age determination by seeking evidence and the age recorded by the JJB board to be the age of the person so brought before it shall, for the purpose of JJB Act 2015, be deemed to be true age of the person. Hence, the degree of proof required in such a proceeding before the JJ board, when an application is filed seeking a claim of juvenility, when the trial court is before the criminal court concerned, is higher than when an inquiry is made by a court before which the case regarding the commission of the offense is pending. That when a claim of juvenility is raised, the burden is on the person raising the claim to satisfy the court to discharge the initial burden. However, the document mentioned in Rule 12(3)(a)(I)(2) and 3 of JJ Rule 2007 made under JJ Act 2000 is also referred, or subsection 2 of 94 of the JJ Act 2015 shall be sufficient for prima facie satisfaction of the court. On the basis of the aforesaid document, a presumption of juvenility may be raised. The said presumption is, however, not conclusive proof of the age of juvenility, and same may be rebutted by contra evidence led by the opposite party. That the procedure of an inquiry by a court in the same thing as declaring the age of a person as a juvenile sought before the JJB board, when the age is pending for trial before the criminal court concerned. In case of an inquiry, the court record a prima facie conclusion, but when there is a determination of age as per subsection 2 of 94 of 2015 Act, a declaration is made on the basis of evidence. Also, the age recorded by the JJ board shall be deemed to be the true age of the person brought before it. Thus, the standard of proof in an inquiry is different from that required in proceeding when determination of age and declaration of age of a person has to be made on the basis of evidence, scrutinized and accepted only if worthy of such acceptance. That is neither feasible nor desirable to lay down an abstract formula to determine the age of a person. It has to be on the basis of the material on record and on appreciation of evidence adduced by the parties in each case. This court has observed that a hyper-technical approach should not be adopted when evidence is adduced on behalf of the accused in support of the plea that he was a juvenile. If two views are possible on the same evidence, the court should lean in favor of holding the accused to be juvenile in borderline cases. This is in order to ensure that the benefit of JJB Act 2015 is made applicable to juvenile in conflict with law. At the same time, the courts should ensure that the JJ Act 2015 is not misused by person to escape punishment after having committed serious offense. That when the determination of age is on the basis of evidence, such as school record, it is necessary that the same would have to be considered as per Section 35 of Evidence Act, inasmuch as any public or official document maintained in discharge of official duty would have greater credibility than private document. Any document which is in consonance with public documents, such as matriculation certificate, could be accepted by the court or the JJ board, provided such public document is credible and authentic as per the provision of Evidence Act, Section 35 and other provision. Ossification test cannot be sole criteria for age determination, and a mechanical view regarding the age of a person cannot be adopted solely on the basis of medical opinion by radiologist examination. Such evidence is not conclusive evidence, but only a very useful guiding factor to be considered in absence of document.
You read that part, which court is to determine when.
Your Lordship, it says evidence, Your Lordship. Then evidence, it says, Your Lordship, the learned court below or the board, Your Lordship. Learned court below has to be remanded back to the learned court below, so that learned court below.
You read that part.
My lord, I have approached,
No, just let him complete.
Yes, Your Lordship, there is no any, so far as the guideline is concerned, there is no any specifically it is point out that the matter has to be sent back or remand back to the learned court below. However, Your Lordship, it clearly says presumption. Regarding presumption, the Supreme Court says, if they come with a document on the basis of which this court can draw a presumption, then can, Your Lordship, the matter can be remanded back to the learned court below or the board, which so that they can determine the age by allowing them to adduce the evidence, Your Lordship, both the parties, Your Lordship, because they have to prove their evidence, Your Lordship, the document whichever they are relying upon, Your Lordship.
Board or the.
Court.
Court.
Yes, Your Lordship.
my lord, kindly see the page number 39 of my petition. I have approached District and Session Court UP after knowing that I am juvenile, my lord. This honorable court was on vacation on January. I approached District and Session Court under miscase, file miscase, one miscase. On 12 January 2023, Learned District and Sessions Court judge has passed an order that I am juvenile after perusal of the matriculation certificate and comparing the original with my annexures. And he declared me as I am a juvenile. Page number 39 and 40. I have annexed in my petition.
And Your Lordship, as for the guidelines, Your Lordship, the Section 9 of the JJB Act 2015 has been, Your Lordship, indicated. Subsection 2 of Section 9 of JJB Act, Your Lordship.
Which 2000?
15, Your Lordship.
2015.
There is no much difference in both the Act, Your Lordship.
in Rule 12 of 2008, Rule of 2017, the Rule of 2007, Rule 12, Sub-Rule 3. It is, first is the matriculation certificate and or equivalent certificate, if any available,
Page number,
as per Rule 12, Sub-Rule 3,
which rule?
Rule of 2007 of JJ Care and Protection Rule.
That is old act, your lordship.
This is
It
all
is in
Act.
this book.
2008, my lord. That is of 2015. I'm yes, yes. What is Rule 7, Rule 12 of Sub-Rule 3, Your Honor. First is the matriculation certificate. So I have adduced a matriculation certificate. Yes.
Which sessions court?
District and Session Court UPR.
You have filed an application.
Yes.
Well, direct the district and.
Yes, your lordship.
sessions court to-
Yes, yes, your lordship.
Is it all right?
Sorry, my lord.
Will direct the sessions court to determine your juvenility?
Your Honor, session, yes, Your Honor. He has already declared me as a juvenile.
Huh?
Already declared me as a juvenile. In my,
Already
declared me a juvenile.
declared you as a juvenile.
Yes, ma'am. In District and Session Court UPR. UPR, District and Session Court UPR.
Your
Session-
juvenility has been determined.
Your Honor, this court was on vacation on January. So I have approached District and Session Court after knowing that I was juvenile in the month of November 2022.
You have approached this court.
No, approached District and Session Court.
Ah.
That declared me as a juvenile, Your Honor, my lord, and I have filed miss case under Section 7A of Juvenile Justice and Care Protection.
Your lordship. This is not,
2020.
this is, they have annexed in page number 39, your lordship.
Page number 39, I have annexed.
This is not as per the provision of section 94 or the Act 2000, your lordship.
Yes.
Only relying on a document, the age cannot be declared, your lordship. Evidence opportunity has to be afforded to both the party, your lordship.
What is, okay.
In a mechanical manner, this order has been passed, your lordship.
Yes, after conviction. Conviction, yes. 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 Thereafter, verbally suggests me to approach before this honorable court.
Verbally suggested you to approach. this
Yes.
court.
I was convicted in 2018.
Your lordship, this order is not in accordance with law, your lordship. Since
have-
it's a part of the record, your lordship, in appeal, your lordship.
We have never come across any judicial proceeding conducted verbally. Already determined. Hmm.
No opportunity, nothing has been given to the other side, your lordship.
Then what is your appeal for? Appeal is challenging the
I'm
conviction.
sentencing, my lord.
Conviction
Only-
on the 302 on merit.
Yes. I'm not challenging the conviction and found guilt, my lord, but I'm
Challenge-
already spent more than 9 years as on today. So as per the Juvenile Justice Act, my lord,
You claim to be a juvenile.
yes, maximum punishment is 3 years. So
But
I've
you-
already spent more than 9 years.
So you have already been declared a juvenile.
In the month of January 2023, after more than 8 years.
That is what I say.
Yes.
You have already been declared a juvenile by the Sessions Court.
But Your Honor, trial court cannot direct the release of accused person.
We may have to set it aside.
Yes, your lordship.
And it is not only challenge.
But your lordship, it was not in the notice of anyone, your lordship. No one is heard, no notice, nothing to the state also, your lordship.
After your original of my this certificate was compared, my lord.
No, no.
After that only he passed.
You went to the Sessions Court, showed the Sessions Court your matriculation certificate,
Yes,
then he passed the order.
yes.
Is this the procedure
Uh,
to be followed in determination of a juvenility?
The court is satisfied that he inspect the documents and there is no reason to be disbelieved. So he passed an order. After comparing the original.
Hard miss. Notice has been served to respondent number 2.
Yes, my lord.
Huh?
Yes. Respondent to
J. Doji, learned counsel for the appellant. Miss he had the learned APP for the state. This appeal File under section 374(2) of the CRPC. Challenges the judgment and order dated 13/3/2018 passed by the Sessions Court UPA in Sessions case number 58/14 within bracket YPA. However, the appellant has been convicted under section 302 of the IPC and sentenced to undergo imprisonment for life with a fine of ₹2,000 with default stipulation. Full stop. Learned counsel for the appellant, Ms. J. Doji, has submitted that the judgment and order dated 13/3/2018 passed in Sessions case number so and so has been challenged on the ground that the appellant was a juvenile when the offense was committed. But the plea of juvenility was not taken as a defense during the plea of juvenility was not taken as a ground defense during the trial.
Yes, during trial.
However, after the appellant was convicted by the impugned judgment and order dated so and so, the petitioner, the appellant, had filed a miscase. Now being miscase number 02/2023 in Sessions case number 58/UPA, 58/14 UPA. For declaring the appellant as a juvenile. On the application filed by the appellant for declaring him as a juvenile was disposed of by the Learned Sessions Judge UPA by order dated 12/1/2023 passed in the aforesaid miscase. However, the appellant has been declared as a juvenile when the offense was committed. Full stop. It is under the aforesaid circumstances submits Ms. Jaya Doji, counsel for the appellant, that the instant appeal has been filed for setting aside of the impugned judgment and order dated 13/3/2018 passed in Sessions case number 58/14 of YPA on the ground that the appellant has already been declared as a juvenile by the order dated 12/1/2023 passed in miscase number 02/2023 in Sessions case number 58/14 UPA by the Learned Sessions Judge UPA. Full stop. On perusal of the order dated 12/1/2023 passed in miscase number so and so in Sessions case number so and so, it appears that learned counsel for the appellant had produced before the Learned Sessions Court matriculation certificate of the applicant. Posto. On such production of the matriculation certificate, it appears that the London Sessions Court has declared the appellant as juvenile at the time when the offence was committed by order dated 12/1/2023. Passed in this case number so and so in session case number so and so. Also, having perused the order dated 12/1/2023, passed in this case number so and so in session case number, declaring the appellant as a juvenile at the time of commission of the office. We are of the view that the determination of the appellant as juvenile by the order dated 12/1/2023, passed in this case number so and so, was not made in accordance with law. First, in that view of the matter, we direct the Sessions Court at UPF to determine the claim of juvenility of the appellant in the miscase number 2 of 2023 filed by the appellant in accordance with law. Post law. Accordingly, the order dated 12/1/2023 passed in miscase number so and so in sessions case number so and so, declaring the appellant as juvenile is hereby set aside and cost. After the claim of the juvenility of the appellant is determined in the aforesaid miscase in accordance with law, report shall be sent here, is not it? Report, the report of such determination may be sent to this court. Okay?
Yes.
Let the appeal be listed after receipt of the order passed by the Sessions Court UPA in miscase number so and so filed by the appellant determining the juvenility or otherwise of the appellant. That's all.
Yes.
Obliged, your lordship.
LCR was called for.
Your lordship,
Then LCR needs to be sent back, I think.
for convocation. Yes, LCR is your lordship, before this court, your lordship, in original, your lordship. LCR is before this court, in original. LCR may be sent back, your lordship, for the purpose of determination of age, your lordship.
Let the LCR receipt be also sent back to the court below.
Yes, deeply obliged. Sir.
Lordship, this litigation is challenging the constitutional validity of Arunachal Pradesh Unlawful Activities Prevention 2014, Lordship.
Mr. G. Carter, Counsel for the petitioner. And Ms. P. Bangu, learned government advocate who pressed for and is granted 8 weeks time to file counter affidavit. Listed after 8 weeks.
Yes, Your Lordship.
May I please, your lordship. Lordship, in this matter, the ministry has already sent a copy of the affidavit duly notarized by the deponent matter. And that the affidavit copy is not available, madam. That is because it is shown delivered, but I have not received the copy. So therefore, madam, some more time may be granted, madam. In the meantime, I'll file affidavit, madam.
What is this PIL about? E-milli. Anything
Yes.
survives in this PIL?
Your Lordship, this BIL is regarding the ICDS guidelines that is not being properly implemented in the Anganwadi.
ICS. What is ICS?
Integrated Child Development.
Okay, integrated child development. Not been followed.
Yes,
In the
there are
Angan-
benefits for the pregnant women, lactating adolescent girls and children of Iyazali.
in the Anganwadi.
Yes, Your Lordship.
Which Anganwadi?
Anganwadi in the Iyazali district, Lower Subansiri, Your Lordship.
Yes. What is to be done?
We were waiting for the counter affidavit from.
By the Union of India.
Yes.
What they are supposed to answer? Union of India. What have you alleged against the Union of India? In not properly not properly functioning of Anganwadi at Yazali.
Yes, Your Lordship.
What the Union of India is to do with it?
It's regarding the
Fund.
so for the infrastructure, there is a Anganwadi building.
Hmm.
Sir, in our statement, we have said, so for the particular scheme, some amount was not released by the central government. So therefore, we cannot make that structure as per the prescribed as given under the guidelines.
Hmm.
So in that regards, the central government was supposed to file affidavit also.
Madam, by their affidavit, state government affidavit, madam, they are saying there is no consequential money. But madam, the ministry has already released the amount as per the instructions, madam. So therefore, to that effect only, madam, we have to file affidavit showing that, madam, the year wise, madam, the releasing of the amount.
So he's saying that the money has been released.
Yes,
Yes, however,
Then what is to be done here?
as of now, we have not received an affidavit in reply, so that is the
No,
reason.
we'll-
We were waiting for that, Your Lordship.
You have heard him submitting. DSGUI has categorically submitted that he has the instruction that the money has been released. Filing of an affidavit is just a formality. Then if the money has been released, then what is to be done?
Then Your Lordship, as we have made the prayers in the petitions, we can. Your Lordship, can you pass a favorable order regarding the prayers that we have put it up in the petitions, Your Lordship?
What is the prayer?
How,
Direct the respondent.
to direct the respondents to implement the section 4 and 5 of the National Food Security Act 2013 in Yazali and ensure the provision of the supplementary nutrition to the beneficiaries is sufficient in quantity and quality. And to conduct a physical assessment of Anganwadis in Lower Subansiri district and then take steps to ensure that all Anganwadis are equipped to fulfill the objectives of providing condition necessary for preschool children's psychological and social development through early stimulation and education. Stress should be laid on the availability of safe drinking water, clean toilets separate for boys and girls, electricity connectivity and provisions of fans and adequate lightings wherever required. And the third is to direct the respondents that section 4B is implemented in its true letter and spirit across the state, and that all eligible beneficiaries are provided the maternity benefits under the scheme with immediate effect.
So what have the state government said regarding, let us go take a one by one. Regarding prayer number 1.
Your Lordship, the case, basically the case is, the conducting counsel is Mr. Mo. So I'm the junior, I've been instructed as per,
I know.
and I've gone through the file as,
See,
yes.
the set of PILs filed by, I don't know you are there or not, regarding PHC. There are more than 20 or 30 such PILs are there since 2019.
Yes, I'm aware of that.
100, over 100.
There
Over
are
100.
22, no, regarding the PHC, we have a 22 PIs, not 100.
See, and this is also regarding Anganwadi. Filed in 2019.
Yes, Your Lordship.
If you don't come up with a concrete proposal, you means the petitioner's counsel. What is to be done in the instant case? These sets of PIL is not going to go anywhere. Huh? Several times, this court has made an endeavor either to dispose of the PIL or to pass some order where some positive directions are given. But you are not rendering any assistance to the effect. See, PIL pending since 2019. Just like that. Today also you are not ready.
Your Lordship, as far as we are concerned, as the PIL is concerned, we are looking for the
Just a
prayers of the
moment.
petitioners, Your Lordship.
Just a moment. I think this scheme comes from central government. Money.
Yes, my lord. Some
Annually.
additional funds has to be released from the ministry, my lord.
Annually.
It states here.
Annually,
Annually, my lord.
is not it?
My lord. This is the my lord instruction.
You may have raised some issues pertaining to the year 2019. What happened to 2020? 22? We are now in 23. So unless you have some concrete proposal in which way you want this PIL to go, in which direction you want, this is not going to go anywhere.
Yes, Your Lordship.
And just periodically it will be listed. You will come, some flimsy counter affidavit here and there, and you are also not ready. Matter will keep adjourned.
Your Lordship, we can't pressure the respondents to reply on time. However, we can only pray, Your Lordship.
We will go by whatever awareness you have made. We
Yes.
can't see, we can't force respondents to file a counter affidavit. We can give them a reasonable time to file a counter affidavit. Now, since 2019, perhaps this court has been very reasonable to grant them time.
Yes,
But if they don't file it, we will go by your pleading.
yes, Your Lordship.
But is not it? Affidavit is for what purpose? To contradict the statements made by you. If they don't contradict, we will accept your statement made in the writ petition as a gospel truth and proceed according to that. Court is ready to do that also. You are insisting on affidavit.
Oh, I'm insisting on the prayer as well. If Your Lordship,
Yeah.
if Your Lordship passes the order as per the prayers that has been put up by the petitioners and give accordingly the instructions to all the respondents, then we don't really need an affidavit.
For that, you will have to argue. Why that direction is necessary.
If there is the case,
You
Your
have to
Lordship,
show that section 4 and 5 of the National Food Security Act has not been implemented in various law. And you have to show that they are duty bound to implement.
yes.
Then only we will be able to pass some order.
Then my humble prayer is that if the argument is to be made, I would request Your Honorable to please fix a date for the senior to have this argument.
On the prayer of E. Millie listed after 8 weeks.
Oblige, your lordship.
Much obliged.
Please, your lordship. I'm appearing for the appellant, amicus, as amicus lordship. We have received the paper book. My prayer is, let this matter be listed for hearing after a week.
On the prayer of this and
Respondent.
amicus listed for hearing in due course.
Oblige.
My lord, I am recording my appearance for contender number 6 today on instruction.
Contempt case.
Yes.
My lord, last order, my lord, 2023, my lord, order dated passed by this honorable court, my lord. My lord granted 3 months more further time to comply with the judgment order passed by this honorable court. My lord.
Which is the order?
My lord, this order passed 2023, my lord.
Page number?
Lord,
Page number?
this is a subsequent order, my lord. After filing this contempt petition, my lord, the order was subsequently passed, my lord, IA. 23 IA
Further direction.
that they sought for 6 months time.
Ah.
And this honorable court was of the opinion that since 3 months already had lapsed, so 3 months, last 3 months further time has been granted.
Ah.
Now, my lord, that time has expired. My lord.
Okay.
Now it is yet to be complied.
Hmm.
My lord, if my brother allows me, my instruction says pursuant to the authoritative directions rendered by this honorable court, and endeavor was made by the contempt number 6 for acquisition of the land, and notification was accordingly issued. And there was a claim and objection, my lord. In the claim and objection, none of the petitioners are the owners of the land.
These are
The
not
final-
these are not the
no,
issues,
no, no.
my lord.
Just-
Once the judgment has been passed, my lord. These
No,
are
no,
not
the-
the issues.
Rajesh, I'm just making a
No, no.
statement. I'm not
No.
contradicting, my lord, not in the merit, my lord.
Ah.
Then what had happened is, then finally what had happened, when there was a claim of objection, none of these petitioners could adduce any evidence to show that they are the owners of those land, one. And then the ownership of this land, which the eviction was done, confined to one Techimania and another one, my lord. That is, and thereafter what had happened, this was forwarded by the contempt number 6 to the state government to take a decision, and the file is pending there, my lord. So let me come back with the detailed affidavit, my lord. Then
My lord, kindly turn to page number, my lord, 27, my lord. My lord, this submission is complete, wholly contradicts what the admission made before this honorable court, and admission has been recorded in this judgment, my lord. Turn to page 27, my lord. Then page 28, my lord. Once the conclusion has been made by this honorable court that the petitioners are the owners and direction has been passed, that too on the admission made by the state respondent, my lord. Now in contempt jurisdiction, my lord, there is no scope to again revisit the merit of the case, my lord.
and
Only the
similarly,
issue,
my lord, similarly, my
only
lord,
the issue, my
similarly,
lord, will ensure whether the order will be complied or not, my lord. This is very unfortunate, my lord. 1 year, my lord.
Who appears for 1 to 5, R 1 to 5?
Lordship, Lordship, this 3 months was issued because Lordship, after the contempt has filed, Lordship, notification was issued in compliance with the order, honorable court order.
Who has filed affidavit?
Lordship,
Contempt में कोई फाइल नहीं है.
2. Respondent number 2.
yes, Lordship.
You are representing 2.
Well, I don't have any idea because I
Okay,
got
No,
instruction
no.
over phone this morning.
Yes, Lord.
You, no, we are clear, you are representing R6.
R6.
Yes, Lord. Sir.
Who is representing 1 to 5?
1, 2, and Lord, Sir, 1, 2, and 1, 2, I am representing Lord. Sir.
You are representing 1 and 2.
Yes, Lord. Sir.
What about 3, 4 and 5?
1, 2, and 4, I am representing Lord. Sir.
Who is representing this?
You be, see, Miss Ete, you be sure of yourself. Who are you representing?
1, 2, and 4, Lord. Sir.
Finally,
Yes, Lord. Sir.
okay.
Lord, Sir, but then here.
Are you sure?
Lord, Sir, 2
1,
and
2
4,
and
I am
4.
very sure, but then one, the name is, Lord, Sir, wrong, Lord, Sir.
Huh?
Course title is wrong, Lord, Sir.
What? Which one is wrong? Which course title is wrong?
Okay, that container number 1, that is Chief Secretary, Mila.
Course title is
Then
wrong.
what is,
That's why I
what is
gave
his
the
name?
name, brother.
Dharmendra. Then Pradhan can be, my lord, omitted, deleted.
No.
This was the information given to me
He
by
is
my
not the
client.
chief secretary.
No, he is the chief secretary, but then, no, his name is not, Dharmendra Pradhan.
Only Dharmendra is saying.
Dharmendra.
Oh. I think
Yeah, notice to be done, you said.
I have been
my lord,
informed also.
You said something about this.
my lord, this, if he's saying that Pradhan is not there, my lord, then
Ah.
this Pradhan can be omitted, my lord.
Okay.
It's not the issue, my lord.
New High Court rule says
According to the.
file an IA for correction in the course title, Mila.
Okay, anyway, you are representing 1, 2 and 4.
Yes, sir.
Okay. What about 3 and 5? No, nobody. Notice has been served. Notice
I don't
about
know.
this one, this one, 3, 5, still awaited.
Sir,
No, 3 and 5 are yet to be served. You want to serve notice to 3 and 5? Okay.
Lord, sir, even I have, this, for the title course name has to be changed. Also.
Okay, just a moment.
Okay, new secretary has come, no? He must have.
No.
Is it
Director.
Director. So Reporani has become secretary. now.
We'll say this respondent number 1 is not Pradhan, but it shall be read as only Dharmendra. Huh? Then you have filed affidavit for 2.
Yes.
What about 1 and 4? They would like to file affidavit. You would like to file affidavit?
That's it. This, the 4 and 1 and 4 will go by the affidavit of this one.
Okay, this 1 and 4 will go by the affidavit of this one 2.
Yes, sir.
Okay. All right.
What's the, if title for, title,
Course
for
title.
its course title is changed, also, for respondent number 4, I will file.
You will file affidavit.
Yes, sir.
Okay. Mr. R. Sonar, learned counsel for the petition. Ms. G. Ete, learned counsel for R 1, 2 and 4.
Yes, sir.
Who submits that the name of respondent number 1 has been incorrectly shown as Sri Dharmendra Pradhan, whereas respondent number 1, the name of respondent number 1, who is the chief secretary to the government of Arunachal Pradesh, is Sri Dharmendra. First, in view of driver, the respondent number 1 shall be read as Sri Dharmendra. Post of art also T. Tara, Learned Counsel for respondent number 6. Office note dated 21/7/2020 indicates that respondent number 3 and 5 are yet to be served. 1, 3 and 5 are yet to be served. Also, since G. Ete has entered appearance on behalf of respondent number one, Mr. Sonar, along with counsel for the petition, has prayed for 1 week time to take press steps upon respondent number 3 and 5. Yes. Prayer is allowed. Steps for submission of notice upon respondent number 3 and 5 be taken by registered posterity as well as the usual process within a week. Listed after 4 weeks. In the meantime, the respondent 1, 4, and 6 may file affidavit if so advised.
But the process still has to be changed by the.
My lord,
Application
what,
has to be made by the-
what,
HCA council to
what Ms. Ate is making a submission is that
post the interview.
the director land management, civil aviation has been changed and new director has come. So in that case, that implement petition has to be filed.
No, she's
Yes, yes.
making submission for respondent number 1, I think.
No,
Four also.
Or 4 also.
Four also.
in that case,
Just
Post-
new incumbent has come.
new
Yes.
incumbent has.
No, but that's all right. This incumbent had also not complied with the order.
Yes, yes, yes.
No,
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 he
sir.
will be there.
He was not there. When this contempt was filed, he was not there. This new incumbent has already come. And at the time of filing only after getting the notice, I told my friend already. At that point of
This
time.
information from my client, my lord, they inquired. After inquiry only, they have
Okay.
given this name to me, my lord.
See,
When they
let-
got the
see,
notice, it's already.
let it remain.
Yes.
You file affidavit stating whatever is required to be stated. You may say that I was not there. It's not it. We don't know at this stage. It is up to them.
Yes.
Yes, sir.
If new incumbent has come, then my lord, we will file necessary application if required.
When was this contempt petition filed?
It was filed, my lord, on 18 January, my lord, this year, my lord,
January.
my lord.
In January, who was the director? Civil aviation?
Mr. Repo Ronian.
At that point of time also, in between only there.
So then, so in January, this man was there. So when the contempt petition was filed in January,
Yeah.
he has to make him a party.
And as far as I
He-
remember,
see,
this gentleman.
He
has
may no
been
longer be there now.
Inducted into IS.
That is immaterial.
Ah.
But when this contempt petition was filed, Mr. Reporonia was a director of civil aviation or not?
Yes, yes.
Then if he wants to implement the new incumbent, it is up to him.
Yes.
But but making this gentleman a party,
Lots of.
In the-
exact time
in-
of transfer, I don't know, but in the January itself, the new.
you
incumbent-
file affidavit.
Yes,
So
sir.
many disputed questions.
Yes, sir.
My lord, so for this 3 and 5, my lord, does this service may be allowed to this official?
So you take steps first.
I'll file my affidavit.
Yes.
appearing as an omega student here in this appeal. And here, original LCR has come and paper book has already prepared. So matter is posted for final argument
Okay.
within 2 weeks.
On the prayer of Mr. M. Patel, learned senior counsel for the appeal and listed for hearing after 2 weeks.
Deeply obliged.
May please, your lordship. In this matter, lordship, the notice for the respondent number 4 is return answer. But lordship, I have made this respondent number 4 being a respondent in this present writ appeal because as per the interview merit list, he is
Maybe, please, Lordship,
above the
I am appearing for the private respondent number 5, Lordship.
5.
I'm already filed the Wakalatnama. So some time may be granted to file our counter affidavit, Lordship.
What is this IA for?
IS for seeking permission to file the writ appeal, Lordship. So that can be considered, but there is another IA that's a file under the Limitation Act for condonation. And Lordship, regarding the respondent number 4, Lordship, I have made him as a necessary respondent.
Just a moment. Now we are taking up which IA?
The seeking permission to file.
Okay,
Yes.
IA 47.
Yes.
You, in 47, you appear for.
I have lordship. 2 weeks time may be granted, lordship. We have filed our written objection, lordship.
Then what happens to
1, 2, 3 are official respondents.
respondent number 4? What happens
4 is the
to-
private respondent. That's why I'm saying that because I have made him as a necessary party, because as per the merit list of the interview, because respondent number 4 also not as made as a respondent in the writ petition. Lordship.
Okay,
But
so you,
he is above than the respondent number 5.
that's all right, but
Yes.
what about notice?
Notice, because I am not aware of his personal, this private permanent address, but I have sent it through the Public Service Commission, where all
No,
the.
nobody is there in Public Service Commission.
Yes. My brother is there, yes.
Service should be completed
Ah.
because he was the conductor and was the counsel representing that private respondent.
I am,
Today he's here.
I am representing private respondent number 5, lordship. Not 4, lordship.
He's not representing 4 now.
Candidate এটা আছিলে না আপনার লগতে ডকুমেন্ট হবে আমার লগতে না
But this private respondent number 4 may not be a necessary party
Yeah.
because as per merit list, petitioner is on top, then
Respondent number 4.
then
Then
him.
No, that is for Mr. Bhatt to take a call. We are not supposed to take a call. What is to be done?
Otherwise, Lordship, this respondent number can be 4 can be dropped because
Okay, you file application.
yes.
Had Mr. M. Bhatt, learned counsel for the applicant. Miss K. Wangmo for OP number 2. No. Who is for 1?
Your lordship, I'm for respondent number 1, your lordship.
Oh,
On behalf of Tijamal lordship.
Mr.
Ketabang.
K. Tawa, learned counsel on behalf of Mr. T. Jamal, learned standing counsel for the education department for OP number 1. K. Wangmo, learned government advocate for OP number 2. Mr. K. A. Appam, learned senior counsel for OP number 3. And Mr.
Lordship, DF Ahmed, lordship.
E.
FA Ahmed.
D. M. A. Ahmed.
DF.
F. D. F. A. Ahmed, learned counsel for OP number 5. Mr. Ahmed, learned counsel for the OP number 5, press for, and is granted 2 weeks time to file objection.
Objection.
Released it after 2 weeks.
Obliged.
Lordship, here I received the objections filed by the other party, lordship. So matter is fixed on Monday or day after tomorrow. lordship.
What is this matter?
This is still appeal and I is for the condonation of delay, lordship.
Okay. You want both the method to be listed up after a week?
Lordship, Monday or Friday, day after tomorrow, lordship.
Why not today? It's a
Uh,
condonation application.
Yes. Actually, just I received the lordship objection also.
On the prayer of Mr. Tapin, for the applicant listed after a week.
Obliged.
May I please, Lord?
Hmm?
May I please, Lord? My part was about.
We had told the PP that we will hear her tomorrow.
Yes, my lord.
So she might be thinking we will hear her tomorrow.
Please, Lordship. Sorry, Lordship, I have for water, Lordship, I have gone outside.
Yes. You may begin your case, you may begin your argument by telling us what led to the arrest of the convict.
Lordship, as per the Lordship, FI Lordship, FI was lodged by the deceased brother Lordship. After that, investigation was carried out. So the arrest was made on suspect Lordship because 161 Lordship statements Lordship are there Lordship. It is there in the LCR record Lordship. Where it was, I have also gone to that LCR. It was revealed from the 161 that the brother of the victim, he was his statement is there about the accused Lordship. So basis of that revelation that arrest may be made Lordship.
What did her brother state in the 161 statement?
Lordship, as per Lordship, the one system as I have seen Lordship, that when the IO interrogated him that do you know this accused before, that he said some months ago, he saw accused that he has forcefully done something to his sister. After that, they didn't know anything about that. After they didn't know anything about that. But during that revelation only that IO maybe after investigation this arrest was made. And Lordship, after arrest also Lordship, the accused he himself confessed before the IO also. And the confession was Lordship in the that confession was witnessed by the rest of the witnesses also. The witnesses statements also there under 161. There before that accused revealed that he has committed the offense. maybe 161 is not admissible, but 164 or 164 also, the accused remain this, that consistent is their lordship, 161 to 164. The same revelation, that same confession was done before the IO and before the magistrate also. Only 313, the statement that the accused was retract his own statement. Yes, these eyewitnesses also there, where they have seen the accused on the place of occurrence, that the place of occurrence on the same day when the incident was taken place. And Dao also recovered from the accused house. The Tokopata, Tokopata is also recovered from his house. And the two ladies who have seen the accused, who have asked him to cut the Tokopata. So, and Rosip, one more thing, 1313 also, that accused was did not deny about this Tokopata incident, Tokopata that have raised before the accused in 313. May Rosip see the 313 in question number 6, Lordship? Paper book 61 page. Yeah, Lordship. That the PW5 deposits that she asked you to cut Toko leaves. Do you have to say anything on this? This is true. And Lordship, as per the eyewitness, that this Toko leaves was cut by the accused with his own dao, and that dao was recovered from his own house also. And Lordship, the accused, the defense counsel remains silent about the blood stain which is found in the dao, Lordship. And Lordship, there in the sample, Lordship, this FSL report. In the Lordship, exhibit number 15, Lordship, this supplementary charge sheet, which is in page 46 of the paper book, where Lordship, second paragraph, may Lordship, the detection of human blood stain in the exhibit A established that this dao was used in killing two diseases of the this case. This is the IO statement. This before that, Lordship, the report, Lordship, S.K. Malik, scientist B, he concluded the report as under 1, human blood could be detected in exhibit A, that is Lordship dao, and blood group could not be detected in exhibit B, exhibit A, because Lordship, maybe Lordship, this could be possible, Lordship, that the day of incident there's a heavy rainfall. It is eyewitness by all the witnesses also, Lordship. Maybe Lordship, due to this rainwater, it could be that washed away and that by blood stain could be diluted, Lordship. That is the reason, that could be the reason, Lordship, that the blood group could not be detected. And because of that, it cannot be compared with the exhibit B. That is the blood stain of the disease. And Lordship, during the whole proceeding, Lordship, this defense was silenced, Lordship, regarding the blood stain of the blood stain on the dao, Lordship, which is recovered from the accused house. And accused also, Lordship, he didn't say anything about it. And this, not only dao, the Tokobata protocol is also recovered along with dao, Lordship. Lordship, 164 Lordship, 164, 161 Lordship, these two has played a vital role in criminal trial. The purpose of contradiction between the evidence of a witnesses before the court and the statement recorded under section 164, 161 and 164 CRPC is primarily to stake credit of the witnesses. It is only to put the court on guard to scrutinize the evidence with great care, Lordship. in the lordships under section 313 CRPC, which is not a substantive piece of evidence, but it can be used as appreciating evidence laid by the prosecution to accept or reject it. And lordship, 164, what is he has confessed before the magistrate lordship? It is lordship, 164 lordship, it voluntarily confession actually lordship, which has never been challenged lordship until this 313, until the 313 happened lordship. And lordship for the credential to question about the 164, you have to establish whether this lordship, there's any lordship lacuna is taken place during the recording under 164. But lordship here in 164, may please lordship will go to the in 164 page lordship, section under section 164 statement. Lordship, it is page 31 or 31 onwards. It is lordship, here lordship, it is already lordship, it is explained by the magistrate lordship that I have explained to the Suresh Mai that he is not bound to make a confession and he does not, if he does any confession, he may be used as evidence against him or her. Or I believe that this confession was voluntarily made. It was taken in my presence and hearing this was read over to the person making it and admitted by him, her to be correct, and it contains a full and true account or statement made by him. And lordship, 313 also lordship, if the accused is lordship retract in the 313 lordship, then that could not be lordship and the ground to lordship to not take the 164 as evidence lordship, because this is taken before 313 lordship and till 164 that consistent is their lordship. Before 161 also, before the seizure witnesses, because in front of other witnesses also, he confessed that crime was done by him. And 164 before magistrate, the same my lord. Lordship, here lordship, actually motive may be there, my lord, because at the time of incident that accused is lordship only 18 years. Or maybe that human psychology will never know lordship at what point what like lordship comes under mind my lordship, because at that point maybe lordship due to the societal pressure he could have done that act lordship, and later on he maybe realized lordship that is a different thing lordship. But lordship here, everything lordship is corroborating lordship till 313. And lordship 313 also lordship can apply lordship judicial mind whether it is the only source to not to convict the accused lordship, because everything is corroborating lordship. And lordship, I may place this judgment lordship. This is the lordship Ganesh Namdev Bharat State of Maharashtra lordship in the year 2008. Here lordship the lordship may see lordship para 19 lordship. I plead lordship, pair 19 lordship. May I please lordship? Pair 19, the accused has at no point retracted his confession since 26 to 96 till his statement under section 313 dated 14/1/97 and except suggesting the PW4 that it was recorded in presence of police or that he was under pressure from police. The suggestion is absurd and need to be deprecated as PW4 being magistrate discharging his official duties has no reason to mitigate the solemn function. PW5 was suggested. He has compelled the accused by beating and allured him. However, to PW4, accused either on 19 to 96 or 26 to 96 did not protest that he was in fact trembling under duress or pressure from police. The accused was made aware his statement can be used against him, but still in his own wisdom, knowing full well consequences of his action, ventured to make confessional statement on oath. On analyzing the evidence of PW4 and reading the confessional statement of the accused, I hold it was springing from the accused without any compulsion or mental imbalance. That is the facts disclosed by the accused. Do corroborate to some of the vital events. The substance and details of the offense committed has been highlighted by accused. This naturally assumes character of admissibility. And also para 620 also, the accused appellant, as stated earlier, only at the stage of 3133 CRPC, exhorted that the confessional statement was under pressure from police. This may not bring his case within the term of retraction of confession. However, if it is treated so, a retracted confession may form the legal basis of conviction if the court is satisfied that it was proved and was voluntarily made. The only writer in this court shall not base the conviction on such confession without corroboration, which in fact is not a rule of law, but is only rule of prudence. And lordship here, lordship, it is lordship dismissed lordship, appeal lordship. Para 26 also lordship, this next page. The findings and the reasons recorded by the land judge to believe evidence of magistrate and to accept confessional statement of accused to be voluntarily do not require interference. Lordship, this 313 CRPC or the statement lordship cannot be ruled out without corroboration lordship. Because till 164 everything lordship is admissible lordship and everything is consistent lordship. This all this statement of the accused himself. Regarding this lord eyewitness, also that two ladies eyewitness, they have also lordship PW lordship, they have examined lordship before the judge lordship, and that maybe lordship as per the apparently submitting lordship that trial is not properly done lordship because defense lordship they have not cross-examined lordship some of the witnesses. That is their lordship. That is I cannot deny lordship. Lordship, there are 145 of evidence which is course examination lordship, which is not lordship fairly lordship conducted during the trial, because many lordship these witnesses lordship they are not lordship examined lordship properly lordship, and 145 evidence is lordship not thoroughly lordship conducted, which is a cross examination lordship. Lordship, here lordship this doctor's deposition lordship. He also lordship here lordship is reflected that this weapon is a sharp weapons like dao etc. It is the page 53. And dao is recovered from the accused house. I'm the lordship here, concluding my submission, lordship, that lordship minor discrepancies cannot be lordship to be ground to lordship to acquit such a heinous crime. Which is lordship, all the evidences against him, lordship, only he only reiterated his own statement, otherwise lordship, everything is against him. Obliged, lordship.
Hard, H. Lampu, Leonard Amicus, and L. Hage, PP, CAV.
Obliged.
May it please.
Yes.
It's also a jail appeal, my lord. I am appearing as an amicus in this case. Conviction is under section 4 of the POCSO Act. RI for 20 years. Why not? I beg to mention item number 18. I have some personal difficulties. Can it be taken up after 2 weeks, madam? Inform the others.
Item number
18, madam.
18. What is the matter?
Land compensation.
Huh?
Compensation, land.
Land compensation?
Yes,
Okay. When do you want?
after 2 weeks, madam.
Okay. Item 18 after 2 weeks.
Okay.
And in this manner, I may be allowed to move this for listing of the read petition number 105 AP 2023. Listing of a read petition
When?
on 3rd, my lord. I have taken consent from my brother.
3rd of August.
3rd, yeah. There is an interim order operating supply of tools under Manrega, my lord.
Okay. 3rd of August. Can you permit listing of the case for 3rd of August now? Today is 25th. We can understand tomorrow something like that. Why don't you make a mention on 2nd of August, if it is not listed?
This advance permission can be granted.
See, advance, if this court can grant permission for 3rd of August, we can grant it for September also. I don't think it is advisable.
Okay, my lord.
It is
Somebody
will-
mention on 2nd.
Yeah, somebody will come and say, they will let this matter in October. So I don't think it is.
I'll make
Yeah.
a mention on 2nd.
Malad, here also said Pere Malad. For day after tomorrow, Malad.
Day after
Day after
tomorrow.
tomorrow for listing the matter, Malad.
Okay, what is the matter?
Transfer matter, Malad, pertaining to transfer matter, Malad. I have taken the consent of the parties,
Pending matter.
pending matter, Malad, for
Okay.
listing, Malad.
Okay.
Day after tomorrow,
Day after
27th, Malad. Diploma.
Lordship, I beg to mention item number 19, Lordship, supplementary hearing. Item 19.
19. Yes.
Leading counsel B. Picha is out of station, Lordship. I have taken the consent from other side also, Lordship.
Okay. When do you want?
After 3 weeks, Lordship.
Okay. 19 after 3 weeks.
Lordship.
On a prayer of the petitioner. Yes.
Much of. My lord, I beg to mention item number 23, madam.
20,
23.
23.
Yes, madam. Motion, item, madam.
Yes.
Later I found some defects in my petition, so I want to withdraw with a liberty to.
You are El
Fresh.
Kurdu.
Good, yes, my lord.
And ask Mr. El Kurdu, counsel for the petitioner, who seeks to withdraw this writ petition with a liberty to file a fresh. Also, writ petition is then dismissed on withdrawal with liberty. Granted is above. Okay, all right.
Obliged.
Be pleased, your lordship. I beg to mention item number 5, my lord. So this matter may be fixed on 4th of August, my lord.
What is the matter about?
Matter is area of salary pending.
Area of
Yes, my lord.
arrears,
Teacher-
arrears salary.
Yes, teachers area of salaries.
4th of August.
4th of August, my lord.
All right, 4th of August. 5th, item 5, yes. Oh, yes,
My lord, I would like to mention item 11.
11.
Yes, for adjournment. I would like to file IA for implement of the necessary party,
How much time?
3 weeks.
On the prayer of RV, on the conference listed up to 3 weeks.
My lord, I beg to mention item number 9, my lord. I'm for respondent, my lord. May I pray, my lord, this matter may be list after 3 weeks, my lord. This,
For filing of a counter affidavit.
and my lord, already filed counter affidavit. It's relating to issuance of NOC for running the nursing institute by this university, my lord.
Okay.
But for that, proposal we have sent, but that status I have to receive, man. That's why. My lord.
Okay, you inform the other side.
Yes, ma'am.
Okay, on the prayer of T. Tarun on the Standing County Health Department, listed after 3 weeks.
My lord, deeply obliged.
May I please, my lord? My lord, I beg to mention for a listing of an item.
Listing of a matter.
Yes, my lord.
When?
Tomorrow, my lord.
What is the matter about?
My lord, it is the
Pending,
petitioner.
pending matter.
Yes, my lord.
Okay. What is the matter about?
My lord, for non-payment of bill.
Non-payment of a bill.
Yes, my lord.
It will, affidavit file.
Yes, my lord. My lord, actually, the payment has not been paid, saying that there was a inquiry and the central government had asked the state government not to make the payment, my lord. But my lord, the matter has been closed now. In that regard, we have also filed an additional affidavit, my lord.
All right.
Obliged.
My lord. My lord, I beg to mention item number 2. With the consent from other side, my lord, this matter may be listed after 3 weeks.
What is the matter about?
Matter about my lord, service matter, it is regularized matter.
In which post?
In contingency to handyman regular.
You wait, we'll see. You wait, we'll see. This is 2019 matter.
Okay, my lord.
You have a right to be regularized.
Yes, my lord.
Okay, we'll see.
Much obliged. May I, my lord? My lord, I beg to mention item number 7, my lord.
7,
Yes, I am for the petitioner.
yes.
So matter may be listed after 3 weeks, my lord.
After,
3 weeks.
what is the matter about?
My lord, matters about the occupying of land by the Central Armed Forces, my lord. Illegally occupying the land.
Okay. On the prayer of Mr.
T. Minky. T. Minky.
Huh?
T. Minky, my lord.
T. Minji,
Minky.
Minky,
Yes, my lord.
the counsel for the petitioner
Yes, my lord. On behalf of Ojing partner.
on behalf of Mr. Okpara. That this matter will be listed after 6 weeks.
Obliged, ma'am.
My lord. My lord, this is contempt petition, my lord.
What is the order?
Yes, my lord, annexure 1, my lord. Page number 9. My lord, the operative portion is in page number 15, my lord. Para 14, my lord. May I
Yes.
please, my lord, in the result, I find sufficient merit in this petition. Accordingly, the same stands allowed. By amendments of this court, the respondent number 1, 2, and 3 are directed to release the compensation amount to the petitioner within a period of 1 month from the date of received a certified copy of this order. My lord, the certified copy had been furnished to the LS contaminers, my lord.
When? On
But-
15th,
Yes, my lord.
Hmm.
15 June.
15 June.
Yes, my lord. Same has been received and acknowledged, my lord.
How many respondents?
Two respondents.
Okay, well, counsel for the petition issue notice returnable in 4 weeks. This steps by both ways within a week.
Published.
May I please, Your Lordship?
Yes.
Your Lordship, this is an application for the appointment of the petitioner on compassionate ground on the basis of office memorandum 0407/2001, Your Lordship. The case of the petitioner is that the petitioner's father was working as a driver in the office of the Deputy Commissioner SEPA for more than 17 years. And he was expired after prolonged illness while he was in service. Your Lordship. And death certificate is annexed here in annexure 1, page number 16, Your Lordship. This is the death certificate of the petitioner's father. After the demise of the Your Lordship petitioner's father, the responsibility of the all the family members, that is the mother, ailing old age mother.
Yes, Tapin.
This is a notice may be issued.
All right. Ivan,
Yes, Your Lord.
for the petitioner Tapin for issue notice returnable 4 weeks, extra copies.
Highly obliged.
May I please, Lordship? Lordship, on behalf of T. Jamal, Lordship, he has gone for a medical treatment today, Lordship. So matter may be listed tomorrow, Lordship.
What is this matter about?
My lord, this is petitioner by way of this petition, my lord, is, my lord, challenging the appointment orders issued in favor of respondents, my lord, which are not in conformity with the recruitment rules, my lord.
Which post?
My lord, post of junior engineer, altogether 6 posts are there, my lord.
Junior-
5 are of junior engineer,
Junior.
among which, my lord, 3 are contractual, 2 are regular, and 1 is of draftsman grade 2, my lord.
Who are you? Who are you?
My lord, I'm qualified candidate for the post, my lord. I'm a degree holder of Bachelor of Civil Engineering.
Is there any rules for appointment?
My lord, there is a recruitment rule, my lord.
All right. You may be praying for some interim order?
My lord, I'm praying for interim order of suspension of the interim orders.
Will we take it up tomorrow?
My lord.
All right. Yes, Tagum. On the prayer made on behalf of Mr. T. Tagum London, Assistant Council for Education Development, this it tomorrow, huh? Give the date. Tomorrow, huh?
My lord.
Briefly, Lordship.
Yes.
My lord, matter before the lordship is pertaining to the transport. My lord, I am the deputy conservator of the forest while serving my lord last posting at the Joyrampur, my lord. Now my service is left for my lord 7 months only. I am going to be retired by 28th of the February 2024, my lord. So in due course of time, my lord, the impugned transfer order was passed on my lord 13/7/2023, wherein I have been my lord posted from my lord Joyrampur to my lord will find the same in page number 18, where I have been posted from the DFO Nampong Forest Division Joyrampur to DFO Southern Resource Survey Division Deomali in Tirap district. My lord, in page number 18.
18, Jerampur to Deomali.
Deomali. I am in the serial number 2, my lord.
And for how long you have been there in Jerampur?
My lord, 4 years, my lord. Since 2000.
Deomali is adjacent to Jerampur.
My lord, this is Joyrampur is my lord in the Changlang district, and the my lord this Deomali is in the my lord Tirap district. So basically, why I am agree, my lord, that I am at the bars of my lord retirement. So my lord, so far, my lord, the cardinal principles of the service is, my lord, I am on the last leg posting, my lord. My pension document has already initiated. It's normally, my lord, initiated in the within the 2 years, man, of the last service.
Where is that? See, Mr. Modi, neither your Jairampur is a headquarter, nor Deomali is a headquarter. The transfer and posting guidelines says on the verge of retirement, one should be posted at headquarter. You know that, something like that. Where is the guideline?
Basically, my lord, one should not be posted at the, my lord, last leg posting at the verge of the retirement.
Where is the
And-
guideline? Where is the guideline?
My lord, that exactly, my lord, there is no such, my lord, but it is assumed in the service rule. At the same time, my lord, there is a, in connection to this, there is a office
there-
memorandum,
No, there is a guideline here also,
my lord.
98 guideline.
Despite of that, my lord, I have submitted the representation
Where?
before the concerned authority.
Where?
My lord will find my representation in the page 21, my lord.
21.
It is start from 2021 is the, my lord, forwarding to the recommendation. My lord may kindly come to page number 20.
When did you submit this representation?
My lord,
14/7.
14/7, my lord. Here, my lord, I am praying for the partial modification. Since, my lord, I am at the verge of the retirement. Therefore, by partial modification, I may be allowed to attest in the office of the CCF Southern Arunachal Circle, Deomali, with the additional charge of the DFO, SRS division, so that I am not required to keep attending the office of the APCCF Itanagar for processing my pension paper, etc. ma'am. So, my lord, at the same time, my lord, I am on a community, commuted leave, man.
You are requesting for posting at Deomali? Huh?
My lord,
You are requesting for posting at Deomali?
my lord.
You have already been posted at Deomali.
My lord, Deomali, this is, my lord, in the other office is, my lord, depends.
Okay, you want to be at CCF's office?
CCF Southern Arunachal Circle, my lord.
Okay, not in the. Okay, no, you have been posted as at Southern Resource Valley Division.
My lord,
You
I
are-
have been posted at the DFO Southern Resource Survey Division, Deomali. So, my lord, I am trying for the partial modification. If, my lord, I am to be transferred, it will be easier for me to, my lord, attest with the office of the, my lord, the Southern
CCF.
Arunachal Circle, my lord. Yes, my lord. So this representation has not been, my lord, attended
Okay,
till today,
you want to be at CCF Southern Arunachal Circle,
my lord.
which is also at Deomali.
Is also at, my lord, Deomali.
Okay. Then why have you challenged this posting?
My lord, despite of this, my lord, representation, my lord, the authority is determined not to consider, my lord, despite that,
Mr. C. Modi, Learned Counsel for the petitioner, and Ms. K. Wangu, Learned Government Advocate for the respondent. This petition is directed against the order dated 13 July 2023, issued by the PCCF, E, F and CC at page 16, by number so and so, whoever the petitioner who has been working as DFO Nampong Forest Division, Jerampur, for the past 4 years have been transferred and posted as DFO, Southern Resource Survey Division, Deomali. Where have you said that in the last, when the petitioner is in the verge of retirement,
Well, my lord will find it in page number,
paragraph?
my lord, page number 25.
No, in your writ petition.
Yes, my lord, my lord, this should be in page number, para 7, my lord. Yeah, this should be, my lord, yes, para 6, my lord. The going to be retired within a 7 months in connection with the circular issued by the DFO Nampong Jerampur on 4/4/2023, whereby the petitioner is going to be retired from the service on 28/2/2024. My lord, the authority has already taken the cognizance that I am going to be retired on this 28th.
What was it, sir? Contending that the petitioner will be retiring from service on 28/2/2024. And no employee who is on the verge of retirement should be transferred. Also. Though the petitioner has put to challenge the aforesaid order of transfer dated 13 July 2023, whereby he has been transferred and posted as DFO, Southern Resource Survey Division, Deomali. Yet the petitioner has submitted a representation to the Principal Chief Conservator of Forest, EFNCC, Governor Ownership Protest, dated 14/7/2023, whereby he has made an appeal for posting him in the office of the Chief Conservator of Forest, Deomali, with additional charge of DFO, SRS Division, Deomali. Also, from the opposite representation dated 14/7/2023, it appears that petitioner would like to be posted in the office of the Chief Conservator of Forest, Deomali, with additional charge of DFO SRS Division, Deomali. Post by the impending order of transfer dated 13 July 2023, petitioner has already been posted as DFO SRS Division, Deomali. Also, thus the primary grievance, though the petitioner has put to challenge the impending order of transfer dated 13 July 2022, however, he has been transferred to transferred from Jerampur to Deomali, the petitioner appears to be not averse to he being transferred at Deomal. Also, the only wish of the petitioner appears to be that he would like to be in the office of the Chief Conservator of Forest, Deomal, with additional charge of DFO SRS Division Deomal, as indicated in the representation dated 14/7/2023, submitted to the PCCF, EFLCC, Government of Arunachal Pradesh. In the view of the matter, this petition is disposed of with a direction to the PCCF. Which responded? No, I said which respondent? Respondent number 2. Is it respondent number 2?
Mallet. Principal Chief Secretary, now.
I don't know. Don't say that. It is direct. Is it respondent number 2?
Yes, ma'am.
Respondent number 2, madam.
Respondent number 2 doesn't appear to be EF and CC. He appears to be wildlife and BD. Huh? There may be several divisions.
Mallet. The respondent in the page number mallet 21.
Direction to the PCCF, EF and CC, Government of Arunachal Pradesh, to consider and dispose of the representation submitted by the petitioner dated 14/7/2022, 23 on its one merit within 2 weeks from the date of receipt of the multiple copy of the.
Until then, my lord, I may not be released.
No, you want to be at Deomali. You immediately go to Deomali.
Lordship, in this matter, instruction was sought from the government side, Lordship.
What instruction was sought for?
Whether the appeal was filed before the deputy commissioner, Lordship.
Appeal was filed. What is here in record?
Lordship, since record has been punished by the government side, Lordship, I have not been punished with a copy, so I will be positioned to the office.
Instruction, I got this record instruction. We are not in the case law.
Okay, containing the appeal preferred by the opposite parties challenging what do you
Lordship, the appeal documents they have furnished, I find that here the signature and all, this is not the original one, Lordship. This is the photocopy one, Lordship. Now, in the photocopy, they have marked.
Can you refresh what the case is about? What is matter is about?
Lordship, actually what had happened is, Lordship, the petitioner here in the respondent, Lordship, in the IA, they have filed one writ petition challenging the order of the EAC, Lordship. Now, in that writ petition, they have contended that the appeal has been prepared before the Deputy Commissioner. Accordingly, the writ petition was disposed of, Lordship. Now, both the party was directed to appear before the Deputy Commissioner. We appeared before the Deputy Commissioner. Now, when the appeal was taken up, now the Deputy Commissioner has clearly contended in his order, saying that no appeal as such was ever filed by the petitioner. So we have approached this honorable court in the form of this instant IA, praying for direction to the registry of this honorable court to register a perjury case against the respondent. That is the case. And the last occasion, the government side was instructed to get instruction whether such appeal was pending before the Deputy Commissioner.
If the appeal was pending, then what happens?
My matter goes, Lordship.
Whether the appeal is pending or not?
Lordship, as per their instructions, Lordship, I find that they have brought one record, Lordship. Okay. But then I find that it's not the original one, Lordship. It's
non-original appeal is there.
Lordship, it's a photocopy, Lordship. In the photocopy, they have marked something, Lordship.
Let us see. Appeal dated? Appeal dated?
23/12/2014, Lordship.
Filed by?
Filed by the respondent. That if original is pending, it ought to have been the original copy, Lordship, but I find that it's not the original, it's a photocopy, Lordship.
Yes.
Yes, my
This appeal was filed by you.
Yes.
Ah.
Since there is a record of filing the appeal before the Deputy Commissioner, this I can be dismissed. Only based
You are
on that, yes.
referring to this.
Yeah.
But this is.
Lordship, may kindly see the last page, the
This is
signatories, that is not original, Lordship, it's a photocopy,
This appears to be a photocopy.
Lordship.
My instruction is that we have filed appeal before the Deputy Commissioner against the order of the EAC.
Subdivisional level K1.
Yes.
Dated 5/11/22.
Lordship, may kindly see, I find that this is not the original documents, Lordship. In fact, the original documents was sought by this honorable court, Lord. Again, I don't know why they have furnished that document, Lordship, which is not in original. Lordship will see the marking in the top, they have marked, Lordship. I find that the ink that is of the latest one, Lordship. If I am not wrong, Lordship. Just they have they might have written it in the recent time, Lordship, in the photocopied documents. If ever the appeal was filed, Lordship, original has to be there in their office, Lordship.
Who were the appellant? Appellant? Who were the appellant?
Lordship, here the dispute was in regards to a river, Lordship.
No, no. Appellant, name of the appellants.
Lordship, they were 36 in numbers, Lordship. Villagers, Lordship. They were villagers. Lordship.
46 in numbers. All of them are opposite party.
Lordship.
This appeal was filed by 9%.
Lordship, maybe they have authorized them, Lordship. In the writ petition, Lordship, 36 of them have approached, Lordship, authorizing 1%.
Right, Mr. J. Learned Counsel for the petitioner and Mr. B. Padu, Learned Counsel for the applicant and opposite party, all the opposite. Yes. Pursuant to order of this court, dated 19/4/2023, Ms. G. H. L. Learned, additional senior government advocate, has produced the record received from the office of the Deputy Commissioner, Eastern District Prosecutor. We have never let this matter be listed after 3 weeks.
Yeah, my lord.
Ah.
My lord, I am for the respondent number 5 and 6.
Hmm.
My lord, earlier the leading counsel was N. Ratan, my lord, in this matter. My lord, I need to take instruction from the client
Hmm.
to for further course of action, my lord, in this matter, my lord. So this matter may be fixed, may be given some more time, my lord.
So, your appointment has been challenged. How much time?
My lord, 3 weeks may be given.
Okay, on the prayer of Mr. T. Tabu. Round of counsel for the respondent number.
5 and 6,
List it after 3 weeks.
much obliged.
Yeah, मैं लेके आऊँ. Yeah, close this structure, no? Yeah, yes.
May I please, Lordship?
Ah.
Lordship, here in this matter, your Lordship, money has been already paid to petitioner, Lordship. So, Lordship, counsel for the petitioner should take instruction from the petitioner and
What money?
Lordship, Lordship, payment, Lordship.
What payment? Salary?
Lordship, yes, Lordship. From the date of appointment to till the date of termination, Lordship. And Lordship, petitioner, they are no more in the job, Lordship.
They are no more
In the job, Lordship.
in the job.
Yes, Lordship.
They were appointed as what?
JE, junior engineer, Lordship.
Hmm. Have you stated in the affidavit file that their salary has been paid?
Lordship.
Have you stated what you have said in the affidavit?
No, Lordship. Lordship, we have got instruction from the department, Lordship.
What is that instruction?
That payment has been made to the petitioner, Lordship.
What is that instruction?
Lordship, payment has been made to the petitioner, Lordship. Salary has been paid, Lordship.
How do you say so? On
Lordship,
the basis of instruction received from the department?
Lordship,
I am asking, where is that instruction?
Lordship, just we have received telephonically, Lordship.
When was it paid? On which date?
Lordship, I don't remember, Lordship.
Huh? You get the instruction tomorrow,
Okay, Lordship.
written instruction,
Yes, Lordship.
okay? Tomorrow it will be possible,
Lordship,
okay? Both the writ petition,
what the petition, Lordship?
okay, on the prayer of Mr.
K. Tabang, Lordship.
K. Taba, and the council appearing on behalf of the Mr. Tijamoha.
Tijab on behalf of
Standing
Tijab.
counsel for just list it tomorrow. Non appears for the petition. Okay, tomorrow, huh?
Lordship. Leave your lordship.
What is the matter?
This is non-payment of bill,
Huh?
non-payment of bill.
Have you filed affidavit?
Yes.
What is your answer?
What we have said is lordship, it was for carrying charge only he was given the work lordship. And it was a note sheet only where he was asked to pick up some lordship GI pipes from Karsingsa to Yangte Transit Store. For that lordship, may come to my page 12 lordship,
Yes.
page 12. The workout is this lordship. And again, from Yangte Transit to this bridge point where the GI pipes have to be carried, lordship. From there is no Pakka road. So in the Kacha road, lordship, head load has been carried by someone else. So head load is 20,000 and for this is 1,12,000. But here he have which have been paid already, lordship, to him. We have said so, lordship. Stated so. But then here he have lordship said 13 lakhs. Which is contradictory, lordship, very much. We have said 1,32,000, but then in 1,32,000, he have written 13 lakhs, lordship. In the last para, page 15 in petition copy, lordship can see that it's 13 lakhs 25,000, whereas it is the kind of same workout. It's 1,32,000. He have made it 13 lakhs, lordship.
Who is respondent number 2?
Lordship. Chief Engineer PhD and WS, lordship. The affidavit has been filed by respondent number 3, lordship, executive engineer.
Respondent 3 or 2?
3.
But in your affidavit, it is who is 2?
2 is chief engineer, lordship.
2 has also filed affidavit.
2 has also filed, lordship.
How many affidavits?
Lordship, in my file is, we have only one affidavit.
Only one affidavit.
Yes, Lordship.
The only one affidavit indicates to have been filed by respondent number 2. And respondent number 2 is the executive engineer.
Lordship may be wrongly, Lordship. Lordship, I'm sorry, this is wrongly, they have written respondent number 2. Respondent number 2 is 3, Lordship. I'm sorry, Lordship, we'll make amendment, Lordship, regarding this. Lordship, can this be taken up after 2 weeks? We'll make the necessary amendment. Lordship will see in para 6, Lordship, 8 bar approved rate for carrier charge, Lordship. From
1
Kasi-
lakh, 1
Kasi-
lakh. 1,12,000, is not it?
Yes, Lordship,
And then additional 20,000
yes.
for Brisbane, total 132.
But then this head load was carried by, done by someone else, Lordship, which we have
And
already
that,
stated.
and
Lordship.
that much you have paid, huh? Is not it? Okay. Non-ABS for the petitioner. Hard Miss GHA, learned government advocate for the respondents. This writ petition has been filed, seeking a direction for payment of rupees 13,25,800 by the respondent authorities to the petitioner. Being the hearing charge
Carrier charge.
of
GI pipes, Lordship.
GI pipes from Karsingsa, Central Store Karsingsa to Yangtze and then from Yangtze to Kume River, and from Kume River, KUMA, to Tali through a headload. Full stop. Para. According to the petitioner, the assistant engineer, PHE and WS division Tali, had issued a note of indent on 15/1/2020 and asked the petitioner to carry the indent materials from the office of the executive engineer, PHED, Central Resource Karsingsa, and told the petitioner that all the bill for carrying charge will be given stock released in the month of March 2020. Full stop. Accordingly, the petitioner, on the basis of the indent note given by the assistant engineer, PHE and WS division Tali, had presented the said indent note in the office of the executive engineer, PHED, Central Resource Karsingsa, and the material was released from the store, which was loaded in the truck hired by the petitioner, and the petitioner was given a challan of the materials by the office, and the material was carried from Karsingsa to Yangtze, and then from Yangtze to Kume River, and from Kume River to Tali to headload, as there is no vehicle transportation. Carrying vehicle transportation for carrying such material, and all the material was deposited in the store at Tali. First, for the opposite carriage of the GI pipes by the petitioner from the Central Store Karsingsa to Tali. The petitioner contents that a bill amounting to rupees 13,25,800 is required to be paid by the responding authorities to the petitioner person. And affidavit in opposition has been filed by the executive engineer. It is by the response, no, number 2. Huh? He is saying this executive engineer, you said that this is an affidavit by respondent number 3.
Yes, Lordship.
Respondent number 3 is an executive engineer at Tali subdivision.
Yes, Lordship.
Now this is this affidavit has been signed by executive engineer in the office of chief engineer Western Zone,
Lordship.
PHE Itanagar, saying that he has been authorized by respondent number 2 to sign this affidavit on his behalf.
Lordship.
So respondent 2 is the chief engineer.
Yes, Lordship.
You will all create all kind of confusion.
Sorry.
Respondent number, counter affidavit by the respondent number 2 has been filed. In the counter affidavit filed by the respondent number 2. In paragraph
Lordship, 5 and 6. Especially.
4, 5 and 6.
Yes, Lordship.
It has been stated as on the 4, 5 and 6. Also. From perusal of the evidence made by the respondent number 2 in paragraph 4, 5 and 6 of the counter file, which has been quoted here and ever, it appears that in the exigency of work, Assistant Engineer PHE and WS Subdivision Tali had issued a note of indent to carry the materials from the Central Stock Kasingsa to Kume Village, or Kume Bridge, to the petitioner, as some of GI pipes was yet to be carried by the main contractor due to delayed payment. Full stop. Pursuant to the posted letter of indent, the petitioner appears to have carried 15.506 MT
Yes, Lordship.
metric ton MT of GI pipes from Karsingsa store to Yangtze Transit store by mechanical means for a distance of 280 kilometers.
Yes.
And then from Yangtze to Kume Bridge Point for a lead of rupees. What is the lead of, lead of 40 kilometer?
Lordship, it must be Lordship head load of 40 kilometer.
No. By mechanical means it says. And,
Which is a Kacha road.
and then
Carriage method.
Yangtze to Kume Point. For a lead of is creating confusion. For a lead of 40 kilometer.
Yes, Lordship.
And then from Yangtze to Kume Bridge Point of 40 kilometer by mechanical means in a Kacha road. Okay. Also. Thereafter, the carriage of the materials from Kume Bridge Point to Tali store by head load as claimed by the petitioner has been denied. Also. For the for carrying the 15.506 MT of GI pipes from Karsingsa store to Yangtze Transit store and then to Kume Bridge Point. It appears that as per the approved rate of carrying charge sorry, it appears that rupees 1,12,189 for carrying for being the carrying charge from Kasingsa to Yangtze Transit Store of a distance of 280 kilometer as per the approved rate, and rupees 20,344 being the carrying charge from Yangtze Transit Store to Kume River Bridge Point of 40 kilometer distance has been paid to the petitioner. Full stop. Thus, thus there appears to be a dispute between the parties regarding the claim of the petitioner for payment of rupees 13,25,800 as the carrying charge of the petitioner for carrying the GI pipes from Kasingsa, this central store Kasingsa, to what was the last destination? Tali store. So, no, where? To Kume River Bridge Point. Is this the last point? Kume River Bridge Point. Full stop. In view of the disputed question of facts as regards the petitioner's entitlement of rupees 13 lakhs 25,800 for the materials the petitioner alleges to have carried from Central Store Kasingsa to Kume Bridge Point. No, to Tali Store. Okay, Kume Bridge Point. This repetition shall stand disposed of, leaving the petitioner to approach the appropriate forum for resolution of the dispute raised in the instant case.
Mayor,
Hmm.
you want to give the content? Yes.
My lordship, I am only for respondent number 5, lordship,
Yes.
NADCL, lordship. Lordship,
My lord, I am for respondent number 1 and 4. 1 to 4. My lord, we have complied, order, my lord.
Where is the order has been complied with? Where is the order? Where is the order?
Annexure 1 page number 14. Paragraph 5.
Yes. Page number 22.
Was before on the basis of the national
Have you filed affidavit?
No, my lord, we need some time to, we will going to file affidavit soon.
No, Lordship, affidavit is there, Lordship. Government affidavit is there.
Yes.
On the explanation of the respondent number 1 to 4, they are saying that they have supplied.
You are representing whom?
1 to 4.
1, 2, 4.
Yes.
I am for 5.
You are for 5.
I am for executing agency.
They may file additional affidavit showing that
Who-
they have complied the order.
Who is to comply with the order? Who is to comply with the order?
Respondent number 1 to 4.
1, 2, 4.
Yes.
In the last order, your lordship, respondent number 5 was killed.
Who is respondent number 5?
NIDC, Lordship. Executing agency, Lordship. Lordship,
Have you
this-
furnished the copy to him?
Not yet, ma'am.
I think Lordship, affidavit is filed by the 1 to 4 respondent, Lordship. And obviously, before filing the affidavit, Lordship, it's served the copy to the petitioner and applicant, Lordship.
Have you stated in the affidavit in opposition? So in the affidavit,
Last page, maybe.
Yes, ma'am.
Last
where
page.
is that?
Lordship, the last annexure, Lordship.
In my affidavit. Paragraph 8, my lord. Page number 7.
Paragraph 8. Why we will list it after week? Mean Ali case has been stayed by Supreme Court, do you know? So nothing is to be complied with. Paragraph 8.
Yes, my lord. May, my lord.
Paragraph 8.
Yes, ma'am.
You read so that we can understand that the order has been complied with.
Copy being there, right? Yeah. Last page.
Yes, my lord. On dated 2023, a letter was received from Director Land Management, Government of AP, conveying the approval of the government of compensation of rupees 3,52,34,769. Only work out in the summary proceeding against the acquisition of the land for ICVR project. Thereafter, on dated 22/3/2023, a letter was issued to General Manager to be under bracket NHIDCL. BO Anani requested for deposit of compensation in the joint account of DC and DLRSO Anini.
What is the judgment?
Judgment
Page number?
Page number 14.
Page number 14.
Next one.
What was the direction? What was the direction? You don't point out the paragraph. Tell the direction. What what was to be complied with? You are referring to paragraph after paragraph. Yes.
The main, education was made in meeting run case. It is justification number 280. And on the basis of this, the case was exported.
So what was decided in the Milling case? Huh?
Petitioners are also entitled to the 27 and 12% interest.
Point out that 12% interest. What can have a 12% interest?
Okay. Paragraph 22. Or page number 22.
You read for yourself and then tell us.
Under the approved upon sufficient merit in this petition and reporting in same are allowed. Admitted in the state respondent and quality state compensation to the petitioner hearing under the resolution 1947. In addition to the state compensation amount, the petitioners are entitled to solution and interest. They are entitled for the solution.
Yes, Mr. Bam. Can you throw some light?
Lordship, here is the case after, if Lordship, lie to the land commission, lie to the payment by the agri agency. But first of all, the state governments to determine how much amounts to be paid to the beneficiaries Lordship. It is the state governments to decide how much amounts I shall pay Lordship. First of all, Lordship, this is to be decided. Then Lordship, in my affidavit Lordship, I said Lordship, if government, state governments directed Lordship, after estimate Lordship, the land commission amount, and if the communication made Lordship, we will comply Lordship. Otherwise Lordship, without Lordship estimate by the state government Lordship, it's not possible Lordship to comply this order Lordship. There is an order Lordship. The state governments to determine the Lordship, how much solutions interest to be given to the beneficiaries Lordship. Petitioner Lordship. It is first to determine the Lordship compensation amount Lordship. Solution amounts. But still Lordship, there is no communications from the state respondent Lordship, container Lordships. Receive solution amounts Lordship and interest amounts. Without Lordship, the amount estimate amount Lordship proceed to given to the respondent amount of 5 Lordship. It cannot be Lordship, proceed Lordship. It cannot proceed Lordship. Lordship, let this matter may fix the Lordship after next, so that I can take instruction Lordship.
Ask Mr. I am counsel for the petitioner. Mr. P. Tagu. Counsel for respondent number 124. 124. And Mr. Jiva, counsel for respondent number 5. This contempt petition has been filed, alleging violation of the order dated 14/6/2022. Passed in WPC 245/2021. Mr. Tagu, counsel for respondent number 124. By referring to paragraph 8 of the affidavit filed by respondents number 124. as the letter dated December 2022. Written to the General Manager P NSIDCL BO Des Anini at Enam Pralo Complex, Kazi, Dibang Valley District by the Deputy Commissioner, Dibang Valley District Anini by number so and so. And the letter signed on 20/12/2022 by the Director of Land Management, Government of AP, written to the Deputy Commissioner, Dibang Valley District, Anini, by number so and so, both are here, produced by him, commits that the order passed in the writ petition has been complied with. In view of the above submissions made, this contempt petition shall stand closed.
Get instruction from my family, whether they have received the amount or not. He is just meeting a document.
Where is the direction to pay you the money? Yes, you point out that.
Page number 22, Your Lordship.
Yes, I'm there in 22.
The petitioner are entitled to pollution and interest.
Yes,
By amendments of this code, the state respondent are directed to walk out and make payment of pollution and interest to the petitioner. As provided in the right to pay and and under the notification, present holding the pay. The petitioner shall obtain a certificate of judgment. Here, order itself, Your Lordship, the respondent are directed to Your Lordship walk out.
affidavit was filed by respondent number 124 on when? 19 May. Where is your instruction? It is altogether a different matter that no proper assistance is equally coming from the council for the respondents. On the prayer of Ivan, instead after 6 weeks. We take back this. We have not understood your contempt case, nor there is an assistant, able assistance coming from other side also. There are some cases filed in the Supreme Court also. 8 weeks.
Much obliged.
Yes.
Lordship, we need some more instructions. Some more time, Lordship.
Mr. Kamruk, Learned LM, Ascending Council LM, and Mr. Ira, Learned Government Advocate for the State of AP, press for and is granted further 6 weeks time to file counter affidavit. Listed up to 6 weeks.
Number 12.
What? Rejoinder. What can you be rejoined? What is the matter about?
Regarding late compensation.
Hmm?
Late compensation.
Do you have any idea how many times you have taken to file rejoinder? Office record indicates that you have taken 10 times. You have taken time on 10 occasions to file rejoinder. What kind of rejoinder? Let us see the matter, if rejoinder is necessary or not. Yes.
Regarding compensation. Will be under the subdivision of ITBP. Under the subdivision of SSP. Total area is 14.36 acres of land. Out of this 14.36 acres of land, 23.6 acres already compensation is
Hmm.
Now, out of this 46.36 acres, Lordship, 16.90 acres amounting to rupees 8 crore 35 lakhs 9,439 and 50 paisa has been paid, Lordship. Now the remaining 23.36 acres, which is still under the possession of ITBP, that has not been paid, Lordship. Lordship, to that effect, we have approached the concerned authorities, Lordship. Page 22, Lordship.
Yes.
I have submitted a representations, Lordship, to the additional deputy commissioner, who is the acquiring authority, Lordship. DDN deputy commissioner, Lordship, ADC, Lordship. At that point of time, the Basar was under ADC's command, Lordship. So I have approached the additional deputy commissioner, Lordship. Now, accordingly, the ADC, he has written a letter to the commanding officer, ITBP, for necessary actions, Lordship. That has not been complied with, Lordship. So why, Lordship, I have come before your Lordship for direction to the concerned authorities to acquire the rest of the land, 23.36 acres of land, as per the law, Lordship, Lara Act, as per Lara, and pay compensation.
Yes, Ms. Wangmo.
My lordship, in this, CGC is the main party, Your lordship.
Huh?
Union government is the main party.
We forget about party. Are you a CGC?
No, my lordship.
Yeah.
In our affidavit, we have admitted that they have received amount 8 crores, 8 crore 35 lakhs 9,000 and 439 rupees, my lordship. And an amount of 11,680 rupees has been paid to the landowners during 1978. We have, payment is not disputed. We don't dispute, my lord, the payment of 11,600. The landowners claim that the said amount was paid at the rate of 500 rupees per acre for the clearance of bamboo and other standing grasses, my lord. This is contested by the ITBP SSB, confirming that the said amount was paid for the land compensation for 23 acres of land. In this regard, there's no record, my lordship, in our official record, my lord, whether it was paid for the land compensation or jungle clearance, my lordship. That's it. There's nothing else, my lordship, in our affidavit.
So petition has to be allowed. You acquire remaining portion.
The main party is union, my lordship. They have to give us instruction.
Yes, come to.
Lord, I have not affidavit in this case, Lordship.
You have not filed
And,
affidavit.
yeah, all the communication Lordship, what the petitioner has annexed in great petition. It first is to the communication made in between Deputy Commissioner and the petitioner, and also with the ITBP. So actually, if at all the land was acquired, Lordship, I also need to get instruction whether it was really acquired or not. Because he has not annexed anything, documents showing that the land in fact was acquired. Or any notification in that regard was issued. I've, from the affidavit filed by the Deputy Commissioner, it seems that petitioners are already in receipt of the compensation. They are not disputing that they have received
8
so
crore.
far, yeah, 8 crore. This crore lordship, if it was received few decades back, it's not a meager amount. It's a huge amount of pay. It might be including lordship, the land and the compensation for the.
All right, this answer for the petitioner. Non-appears for the Union of India. Are also Ms. K. Wangmo, on the government advocate for respondent 2,
And 5.
5. 2 and 5, huh?
Yes, sir.
2 and 5. And Mr. D. Kamduk, on the standing council for the Land Management Department, representing as 3 and 4. On the prayer of Mr. J. Jini, Run of Council for the petition of district after 8 weeks, enabling filing of the reason the company.
Much.
Hello, in item number 13, I am appearing for private respondent number 2.
Yes.
My lord, may kindly take note of the previous dates or previous orders of this honorable court. My lord, the petitioner in the present case, he died in the year 2021. That fact was brought to the notice of this honorable court for the first time on 1/8/2022. My lord, may kindly have a look at the order dated 1/8/2022.
Just a moment. 1/8/2022, my lord. 2022. You have put a petitioner.
Lordship, I am put a petition.
You want to say anything?
Lordship, yes, we have to file our substitution application, Lordship.
You are still praying for
Lordship,
time to file substitution.
because Lordship, they are facing certain difficulties who has
Okay,
to.
all right. Yes, you are pointing out what? Order dated?
1/8/2022. my lord.
Yes, 1/8 done.
First time, the fact that the petitioner was dead was brought to
Some-
notice of this
okay.
court.
All right.
On that day, my lord, time was sought for filing appropriate application for substitution. Subsequently, the case was listed on 4/2/2023, my lord. 14/2/2023, sorry. Similar prayer, my lord. Further 4 weeks time was granted.
Mr. J. General Counsel for the petitioner. Mr. S. Tapin, what is the matter is about otherwise?
Lordship, it's, we have challenged the arbitration proceedings, Lordship.
Okay. S. Tapin, non-senior commander for 1 and 2, and Mr. 3.
R.L. Thupin.
R.L. Kumar, learned counsel for respondent number 3. Despite an opportunity to granted to the petitioner. Just on the prayer of the learned counsel for the petitioner. This matter was adjourned to enable filing of an interlocutory application for substitution of the legal representatives by the order dated 1/8/2022. Since then, this petition was listed on different occasions. Purpose of purpose on each of the occasions, the learned counsel for the petitioner had taken time to file an application for substitution of legal representative. But till date, no such application has been filed. In view of the above, this petition is still dismissed for non-prosecution.
Lordship may kindly give me a last opportunity since they are facing certain difficulties, Lordship, to ascertain who will substitute, Lordship. That is the difficulty. Otherwise, I could have filed, Lordship.
File an appeal to this order.
Lordship may please, Lordship.
We can't say.
I'll instruct my client to come up with myself.
May I lordship?
Yes.
Your lordship, service to private respondent has been affected by paper publication. So service may be deemed to be completed upon respondent number 6. I have also filed an affidavit in this that behalf. My lordship, private respondent number 5, 7, and 8 have not filed affidavit yet.
This notice by newspaper publication was for whom? Respondent number 6 only.
Yes.
5, 7, and 8, Lordship, I am representing.
You are representing.
Lordship.
What is this matter about?
This is service matter relating to promotion.
Okay. Where is the notice? Lingdom Komi. Okay. All right. Miss
Elisha.
L also on the council petition. There is central government also.
No, Lordship,
Yes, stopping. Government, Senate government for R 1, 2, 3, 4, or 4. J is in for 5, 6, 5, 7, and 8.
Lordship.
In view of the order of this court dated 21/4/2023, the petitioner has filed an affidavit enclosing the Arunachal Times newspaper published on 3rd May 2023, where notice upon respondent number 6 was published indicating the next date of appearance is 5/6/2023. Also, when the matter was taken up on 5/6/2023, this court, by taking note of the affidavit filed enclosing the newspaper, had directed the registry to put up a note as to whether any Wakalatnama has been filed by the engaged counsel of respondent number 6 on the next day. Puts the person thereto. In the person thereto, registry has put up a note dated 21/7/2023, wherein it has been indicated that no Wakalatnama has been filed by the respondent number 6, engaging counsel to represent us. In view of the above, notice upon respondent number 6 is deemed to be served. You have filed affidavit?
Lordship, I'm to file, Lordship. I'll file.
Okay. Government is filed.
Government, they-
Government, you, with how much time you'll file?
Lordship, 1 week, Lordship.
Okay. State respondents have filed counter affidavit. Was Mr. Genie, also representing respondent 5, 7, and 8. Press for N is granted 1 week time to file counter affidavit. Please keep after 3 weeks. Okay.
I
don't know what Yes, could you notice complete? No. DSGY. DSGY.
Yes.
DSGY is not bordered
Yes.
with your,
On last
what to
occasion,
do?
they seek time to file affidavit for appointment of arbitrator.
Mr. B type of dear, counsel for the petitioner. None is appeared for the respondent. In view of the above, list it again after 2 weeks. STS.
My lord.
Yes.
My lord, step upon respondent number 6, private respondent number 6 has been incomplete, so we may be allowed to take fresh step.
What is the matter about?
So, my lord, this matter is about construction of the petitioner firm was awarded for construction of 40-man barrack at Bamang ITBP post. Initially, by virtue of L1, the petitioner firm was awarded the work, and as accordingly, performance guarantee was also submitted, and during the work was ongoing.
All right, in view of the office note dated 21/7/2023, Mr.
B. Kamdak.
B. Kamdak, the counsel for the petitioner press for and is granted further 1 week time to take press steps to service of notice of respondent number 6. List it after 8 weeks.
Most obliged.
Yes,
My lord, I may be allowed to take fresh step upon respondent number 2, my lord.
respondent number 2.
Yes, my lord. I'm on behalf of Mr. P.K. Tiwari, sir, senior counselor, for respondent number 1 and respondent number 3.
1 and 3. Okay. Miss
T. Rimi.
T.
Rimi.
Rimi,
Yes, my lord.
the counsel for the petitioner, and Miss
T. Paldron.
T.
Paldron. Paldron. Paldron.
Okay. The counsel for respondent number 1 and 3. In view of the office note dated 21/7/2023, Ms. Swenson, the counsel for the petitioner press for and is granted further 1 week time to take press steps for service of notice of the respondent number 2 by both ways. This take after 8 weeks.
Yes, ma'am.
My lord has heard this matter many occasions.
Many occasions.
Yes, no, sir. But we could not, the argument could not be culminated into this passing of a judgment or order. In fact, here,
That means
Lord-
there is some difficulty in the case.
my lordship, only case is that I was appointed as a casual labor in the year 2000. And rest of the private the respondents, they were also appointed as casual labor initially. They are all junior to me. They were appointed from the year bearing from 2006 to 2009. So some of the respondents, they are junior to me by 8 and 9 years. But despite that, the authority, the respondent authority, they have given them the gradation. Shall I proceed, Lordship? This is actually my case of the petition.
No. This court had not heard this matter. Some other court.
This court also lordship has a,
There was a AG's assistant also sought for.
yes, he also was sought for, and in the last occasion, AG was personally assisting this honorable court also.
Then what happened?
This honorable court or some other court, I exactly do not remember, but AG was.
Then what
also there.
happened? AG was asked to address what?
He was asked to address on the issue as to how the WC, how the upgradation is made as a WC from contingency staff. That is the issue was to be clarified by the
Casual.
yes,
Uh,
AG.
Has it been clarified now?
Lordship,
Has it been clarified now?
they are clear now, Lordship, not that.
My lord, may peruse the order earlier 9/6, my lord, that I think he dispensed it well.
9/6.
Yes,
2023.
yes, to 23.
Yes.
My lord, basically, the case of the petitioner is that petitioner was appointed as casual labor in the year 2001, and the date precisely is 19/5/2001. Lordship will find my appointment.
Just. See, this matter was heard in part. It was kept as a part heard. Then matter was listed to be, matter was directed to be listed on 26/6. But that bench perhaps was not available on
Comment
that day.
was, I was supposed to produce this DPC original, Lordship. So
On
the
that day.
DPC, original of the DPC is with me now. There is a honorable court's order directing me to produce this original, Lordship.
I would pray your lordship to take up this matter and dispose of the matter to the lordship, because lordship, this matter has been pending since 2019, lordship. It's in fact a old case, lordship. In view of the fact that the petitioner is a poor casual worker.
Lordship, may I submit the report here?
little clarification, let us have some clarification on this.